Call 116252, State of Kansas versus Terry Ballou. Counsel. While counsel's approaching, I think most of those in the courtroom recognize Senior Judge Malone, but for those that may be watching by video, I'd like to introduce him as sitting in place of the Chief Justice. Mr. Meharry.
May it please the court, Peter Meharry for Terry Ballou. If I could have 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. In this case, Mr. Ballou was convicted of 1 count of rape and 1 count of aggravated indecent liberties. He was sentenced to a controlling term of life with a minimum of 50 years before parole eligibility. The convictions arose out of an incident that occurred on April 13th, 2014. On that day, Virginia Norris, who lived with Mr. Ballou, testified that she went out to get some smokes and some alcohol. However, the store was closed, so she returned home. She testified that when she returned home, she walked in on Mr. Ballou molesting his daughter. As I said, that led to charges. While Ms. Norris did not initially report, it eventually did come to the attention of law enforcement, leading to the charges in this case. The state also did a forensic interview of the victim in this case, in which she made allegations of not only the alleged abuse on April 13, 2014, but also other instances of abuse by Mr. Ballou. The jury convicted, as I said, of 1 count of rape and 1 count of aggravated indecent liberties. It acquitted on 1 count of aggravated criminal sodomy. We have raised several issues in our brief, and I'll just start with the first issue that we have raised, and that deals with prosecutorial error. And it's our contention that the state did commit prosecutorial error in closing arguments when it expanded the date range for the alleged crimes. This case, the crimes were alleged to have occurred on April 13, 2014. Ms. Norris testified to that fact. The complaint listed the date as on or about April 14th, 2013. April 13th, 2014. However, in closing arguments, the state told the jury that the on or about language could encompass more than just that day. The state argued that it could encompass the entire 4.5 months that Ms. Norris, Mr. Ballou, and his daughter lived together. The Court of Appeals agreed that was error to expand it beyond that date-specific language.
Did they or did they assume error?
They said they assumed, for purposes of deciding, or not deciding, I should say, that this was error. It's our contention that it is error. And I know the state cross-petitioned on the issue, but we believe that it was error because in this case, Mr. Ballou relied upon the state's allegation that this occurred on a date-specific day, specifically on April 13th.
You presented this as prosecutorial misconduct, correct?
I'd have to
or
look.
Error, I'm sorry.
I
Give my new.
I could have, I don't know. But it's obviously error at this point in time with this court's case law. Is how we presented it.
Okay, now you've confused me. So are you not presenting it as prosecutorial error? You're presenting it as what
No.
then if it's not that?
No, we are presenting it as
Okay,
prosecutorial
I'm
error,
sorry.
Your Honor. I'm sorry.
So given that, our test then isn't it that whether the prosecutor exceeded the wide latitude allowed during the opening statement?
This was in closing, but yes,
closing,
that
yes.
is the standard, Your Honor, is whether or not this goes beyond essentially proper argument.
And your contention is that the prosecutor made a legal error, a misstatement of the law? Would that
Correct,
be
Your Honor.
correct? So what is the Kansas authority that would have told the prosecutor at that point in time that she was outside the wide latitude, that she was making a misstatement of law? When I look at your Court of Appeals brief, you cite an unpublished Court of Appeals decision that isn't binding even on another Court of Appeals panel, then a North Carolina case and a Missouri case. And so I'm wondering, when we look at prosecutorial error, does there have to be more clearly defined law before we talk about an error by a prosecutor?
I don't think there has to be more defined law or a case that is specifically on point. The problem we have with what the state argued is that the state, throughout the case, throughout the trial, said this happened on April 13th. My client relied upon that. He based his defense upon that.
That sounds to me like you're talking about a due process argument, that he was denied due process. But you have framed this as error by the prosecutor. And the prosecutor has presented to us some authorities. We may not accept their authority, but they have presented to us what I think most of us would couch as a good faith argument as to why the statement was a correct statement or an allowable statement. So how do we say that's error by a prosecutor?
Because the prosecutor, as I said, they went throughout this case saying that this happened on this specific date. They knew that that is what they were charging and alleging that my client did. They knew that he was relying upon that. They sat through that trial. They saw the evidence he put on in his defense. They knew it was based upon their specific allegation that this happened on a specific date. And they should know that they can't then change up at the end of the trial to something different. The state can't change charges in closing arguments. They should know that. And this has the same effect because my client is basing his defense on the allegations by the state.
Why isn't it a misstatement of the evidence as opposed to an error of law?
I think it's a misstatement of law because the state said this language means X. I don't think they were misstating the evidence.
But you're trying to pin your case on an interpretation of the language on or about, right?
Our argument is that in this case, on or about does not mean what the state argued.
But what you just recited was all the evidence that came in at trial. So it just seems to me like it makes it seem like a misstatement of the evidence, potentially at least.
The state did not misstate the evidence.
So did evidence come in of other incidents outside that date?
Evidence did come in of other allegations of abuse outside that date. Okay. That was subject to 6455 pretrial motion. Okay.
So how was your client denied sort of notice then, if evidence did come in outside that date?
Because he did not understand that that was the basis for the charges. His understanding throughout trial was that the charges were based on a specific incident that Ms. Norris testified to that occurred on a specific date, April 13, 2014. And if you look at his testimony, my client testified in his defense, and he had his son testify. Their testimony centered on what they did on April 13th. He made general denials, but he was never specific about any other date or any other defense beyond the specific date that was charged against him. So our argument is the state didn't misstate the evidence, but what they were arguing to the jury is that this on or about language means a date range. And at this point in trial, because my client relied upon the allegations that they made, the claims the state made that this occurred on a specific date, the state can't change up at that late date to the detriment of my client and his ability to A, have notice of what he is being charged with, and B, his ability to present a defense.
You're saying that that other evidence was uncharged conduct, and it was in fact subject to 455, and you got a limiting instruction and everything.
That was subject to a 455 motion. The district court let it in. It is uncharged conduct. The allegations throughout the case were specific to that April 13th date. Virginia Norris testified at trial to what she saw on that day. She testified at trial as to how she knew it happened on April 13th. And that was what my client was charged with. But by expanding that range in closing argument, they opened it up to possibly being other allegations of abuse, allowing a conviction. So we believe it is error.
So your argument is the harm here is not that the wife or significant other, girlfriend, longtime girlfriend, went for cigarettes and came back early on a different date, the harm is that the propensity evidence may have confused the jury as to what acts were charged. That a different act that was offered for propensity, not for this charge, may have been used to convict. Is that your
That is
complaint?
correct, Aaron. That is part of what we see as the harm, is that potential exists because, as I said before, during the forensic interview, the alleged victim in this case did state that there was other instances of abuse over a period of time. However, the date here of April 13th is what the state charged my client with abusing the victim on that date. The other harm, we would argue that there is more than just the possibility that uncharged conduct allowed a conviction in this case, is that my client had no opportunity to prepare defense. He was not given due notice that the charges covered this time span as opposed to the specific day of April 13th.
Let me move you over to the forensic interview before we run out of time here. What specific opinion did Jennifer Stockard give that you object to, that you think subject to the Daubert rule?
She used her specialized knowledge, specialized training to conduct an interview.
I don't care about that. I care about what opinion she gave that you object to.
The whole interview, we believe, is expert opinion.
How?
Because it is using specialized knowledge and specialized training to get a result.
Did she give an opinion that the methodologies she used provided reliability to the answers that were given in the interview? I didn't see that.
She didn't testify to that specifically.
She did not.
She testified.
So what opinion I'm trying to get you to admit that there's no opinion that she's given. I realize you don't like the technique or the experience that she had about the interview, but it seems like the statute is specifically key to the giving of an expert opinion, and I don't see an opinion in here. So if you think there is one, just point me to it so I can focus on it.
She did not, in that regard, she did not give an opinion. Okay. But I still don't believe that you can divorce the result, which is the interview, with the process. To me, and I use this example in my petition, everybody knows what .08 is in DUI. Everybody understands that. But we still have to have expert testimony, somebody specially trained to do the testing to get that evidence in.
That's a scientific test that leads to a defined result.
Correct.
We're talking about an interview here. There's no testing, there's no way to measure whether this child told the truth or lie by a protocol that leads us to that result.
And that is our problem with it. The state paints this with the veneer of expert opinion, expert testimony. They get up and have in this case it was an individual by the name of Ms. Stockard, testify about her resume. They go through her specialized training, what she's done.
How is that different than you put a police officer on who's interrogated somebody and you go through their background and their training as a police officer before they interrogate?
I don't think they go through the background of police officers like they do with forensic interviewers. They ask the police officer, what do you do? I work for Topeka Police Department. How long you been there? But they don't go into their specialized training in interviewing child victims and how they follow those protocols in these interviews. The state is building this up as, okay, we do A, B, and C because that is what we need to do to get good, honest, reliable results.
And that's what's not said in the transcript. That's what I'm trying to get you to. Your argument is that's implied, right?
It is very much implied.
But it's never said.
But I don't think you can ignore it.
Let's just acknowledge that it's not said. So now the question is whether it's implied.
For me, it's not a question of whether or not it's implied. The reason they go through their background is to show that they've had this training dealing with a special subset of individuals, child victims, so that they do these interviews properly to get good, honest, reliable results.
Can you give me an example of the direct examination of Ms. Stockard where the state asked a question that was intended to imply, from your perspective, the reliability of the answer?
Your Honor, I don't have the record in front of me, but I can look at it during the time my colleague is up.
Because I didn't see it. I mean, I read the transcript, and what I see is she says, yeah, I've had this training, and the training says to ask an open-ended question. So I asked an open, or what, but I don't see anywhere in there where they are moving over to reliability. I also don't see on the defense side of it an attack on the reliability of the answers given in the interview. There's Dr. Barnett gives some stuff about, well, I don't like quite X or Y in the approach that they use, but he never gives an opinion that says that makes the results of the interview unreliable. Am I reading the record correctly?
I guess when I reviewed the pretrial hearing on the admissibility of the forensic interview, maybe he didn't say it in those exact terms, but the way I understood Dr. Barnett's testimony was that she did not follow these protocols. She did these certain things improperly, and that taints the interview.
My frustration is I understand when we're doing a photo lineup, and you hand one picture to a witness, and they go, yeah, that's the guy, or you hand 3 women and 1 man, and your suspect's a man, they go, well, that's the guy. I understand how that kind of cross-examination or expert examination can lead to a conclusion about reliability of the result. I don't see it in this case, and that's where I'm really keep banging on you about this, because
Sure.
I'm having, the Court of Appeals said this isn't expert testimony, so I'm trying to draw out your objection to that conclusion, because I look at it and I kind of agree with the Court of Appeals. I don't see it.
I guess our view or our contention with the Court of Appeals is the forensic interview is the product of Ms. Stockard's specialized knowledge and training and the application of that specialized knowledge training in the interview, and we don't think you can divorce the result from it. They have to show that this specialized training, this interview process, is reliable. And if the process is not reliable, the end result is not going to be reliable. Just as much if you have scientific testing that uses shoddy material or inconsistent protocols, you are going to get inconsistent results. That is what we see as the problem with this, is divorcing the process from the results. And the interview is the process, or I should say her training, specialized training, experience, whatever, is the process that she uses to get the result, which is the interview.
Other questions? Thank you, counsel.
Thank you.
May it please the court, Elizabeth Sweeney, Reader, Miami County Attorney. Your Honors, I'd like to start in kind of reverse order here because of the comments counsel just made. Under his arguments, anytime you had someone that gave an interview, you would have to go through the same process of determining whether like with law enforcement, the example given by the justice about law enforcement, that any of their interviews, you would have to look at whether their training was resulting in an interview coming a certain way. And what we've argued from the beginning of these motions in district court is interviews of any type and child forensic interviews. These are not something that is a scientific methodology.
But counsel, isn't it, well, is it true that the manner in which the interviewer is introduced to the jury is intended to bolster the credibility of the interviewee's answers?
Your Honor, I don't believe so.
What was the interviewer identified as a forensic interviewer to the jury?
No, Your Honor. Ms. Stockard, in my direct examination of her, she stated her name, she stated where she worked, how long she had been a social worker, that she had been a social worker, I think it was about 25 years at that time. She had her education, she had had training in working with kids, she had gone to this interview process. But we did not go into anything about the process, what the training was like.
So she wasn't called a forensic interviewer?
We did not call her a forensic interviewer. In fact, the only way that it came out at trial, what the protocol was, what the process was designed to do, was through defense counsel's cross-examination. Nothing that we did was any different than I do with law enforcement.
So you contest the representation of the way that the defendant has argued this issue, that the state was effectively bolstering the credibility of the interviewee by going through the resume.
I do, Your Honor.
Okay. Thank you.
It's the same way that I would do with any other witness that's a professional type witness. So we do believe that Ms. Stockard's testimony, she was testifying as a fact witness. She gave no expert opinion. There are cases where you can have an expert give an opinion about child abuse, but that was not something that was done in this case. Defense talked about, he made some statements that I would disagree with, and you would have to go back to the transcripts of the pretrial hearing with Dr. Barnett. That was a full day pretrial hearing, and on cross-examination, Dr. Barnett actually agreed with the state that in this case, this interview was pretty good. Ultimately, he talked about how the victim was able to correct the interviewer, how she was able to give detail, and she was a pretty smart kid. So when defense called Dr. Barnett at that trial, he did initially go into how the protocol was bad, how it wasn't what he would do, how it's not applied, but upon cross-examination, he backed off of a lot of those statements. And in fact, we went through the interview of the victim and stopped at multiple places, and I asked him to point out, where are you saying this was leading? Where are you saying this was a problem? And the transcript will show that in many of those places, he really backed off of those statements in this particular case.
So in your mind, the way that you attack the reliability of the what's called child first finding words protocol is through cross-examination and defense expert, as opposed to the state having to show some reliability in the protocol in the first instance.
Yes, Your Honor.
That's how it's done.
I believe so.
Because my concern is what happens if the child first protocol at some point is rendered just a totally invalid measure? What happens then? I mean, you could still utilize that?
If for some reason it was rendered totally invalid, then I don't know if you could do that. However, all of the forensic, and this information is also in that pretrial transcript, all of the protocols are essentially the same. They've all been based on research, whether you're talking about child first, whether you're talking about the predecessor, the name is Finding Words. Whether you're talking about some of the different protocols that Dr. Barnett used, and I believe he even discussed this. They all came out of a series of cases, starting with the McMillan cases and then going into the Michaels case, where kids were just being asked crazy questions. They were being given gifts to talk to investigators. They were being called little detectives. So all of that those bad things that happened were then taken by all of the different protocols and made so you're not supposed to ask the
That's the problem
questions.
here is that we have evolving kinds of science with these things. And often in the future we find that the measures we were utilizing in current day then or now or in the past were completely inaccurate. And so how do we protect against something like that? What's the harm in putting it through a Daubert kind of analysis? What's the problem with that?
Well,
and
I
just
think
ensuring that, at least for now, it's reliable.
Your Honor, I think that it doesn't need to go through a Daubert analysis because it is not, it's not giving an answer. Going through the interview doesn't mean that a child was abused. It's not like going through, I know the court had looked at some of the scientific testing, the psychological testing when looking at like sexually violent predators.
Well, it's designed to give, you would agree, it's designed to give accurate answers to questions, isn't it?
It's designed to give accurate answers to questions, but it's not designed to say that a child has been abused or has not been abused.
So, counsel, if I were to make the statement, finding words is the best technique to elicit factual answers from a child victim, would you agree that that statement is an opinion?
Yes, I would.
And it just seems to me that, again, piggybacking on Justice Rosen's questions, and it seems to me that the defense is arguing, look, whether just because that opinion didn't show up in baldface in the transcript, that's what this entire witness was communicating to the jury. The opinion that these techniques are the best techniques to use if you want to elicit factual answers from a child victim.
I disagree that that's implied, Your Honor. I disagree with defense position completely. If there's any implication that this is the best or that it's getting an accurate answer.
Was the technique that was used in the interview elicited on direct examination or on cross-examination?
The technique was elicited on cross-examination. All that I put on.
So the state didn't ask, what techniques do you use?
No,
Tell me
Your Honor.
about finding words or whatever the technique.
I did not.
Okay.
Was that because you were concerned about this issue, or is it just you?
That's just my practice,
Just
Your
your
Honor.
practice.
I have never had an expert witness come talk about whether a child has been abused or not, or what their proper techniques are on how to do anything like that. And it had never come up until this particular case in our jurisdiction. Ms. Stockard and I have worked together for over 13 years, and the same beginning foundation questions are the same in every case that we've worked together.
I'm not sure I heard an answer. If it's determined that the technique that Ms. Stockard uses is bogus, that it creates false positives, it creates evidence that is wrong, it's an unreliable scientific method under our old Fry test, how does the defendant protect himself or herself from that? If you don't have a testing somehow, a Daubert, Fry, or some way to attack the methodology used. I mean, how does it get done? That's my colleagues asking. How does the defendant protect the defendant against a bogus methodology that creates unreliable evidence? And that's what we're dealing with, is reliability of the evidence, isn't it?
Yes, Your Honor. I believe that the defendant would do what he did in this particular case. Was they did try to suggest that Ms. Stockard used leading questions, that she didn't follow up on other hypotheses. And this kind of also goes.
Would it be akin to a forensic crime scene investigator who simply contaminated DNA evidence? I mean, is that how you would attack this from a defense perspective? You would say it's bogus, that the methods used by this investigator just completely contaminated the evidence.
He certainly could have argued that. I think the district court was very clear in her rulings that defense was defense was able to bring back Dr. Barnett or another witness if he wanted to attack that methodology, that he could do that, but that Ms. Stockard was testifying as a fact witness. We do think, however, if there was a need for a Daubert hearing, we do not believe that the child first finding word protocol would fail. It has been developed over many years with different research. It has, it's not something, as defense counsel initially had argued, and I can't remember if they put it in their petition for review, but I'm sure it was in the Court of Appeals brief, about certain factors that under Daubert that have to be looked at. Daubert was supposed to be more expansive than Frye, and it says in those statutes that those are not the only items that have to be looked at, especially when you're dealing with something that is not a hard science like the DUI result, where you input breath in, you get a result out. Just touching on the first argument that defense made as far as the defendant being denied the ability to present a full defense.
What was the purpose of expanding the date?
Your Honor,
is there any question that the acts that formed the basis of the complaint that was being prosecuted occurred on the 13th of April? Was there evidence that came about that made that equivocal on that date?
Your Honor, I don't believe so. I was not the prosecutor that gave closing arguments, so I don't know what came out at why that came out.
What would be the point? You're representing the state. Give me a reason for the prosecutor to expand the date when there was no evidence to indicate that the acts being prosecuted occurred on any other date, other than to bring in, to adulterate it with the propensity evidence that happened on another day.
Okay. Your Honor, I do know that within the evidence that came in, and I believe some of it was cross-examination of Ms. Norris, some of it was witnesses presented by the defense. There was some evidence presented that all of the family was seen together in church the day after this happened, and they acted like nothing had happened. There was some evidence that talked about how Virginia Norris initially thought it happened on Easter weekend, then she thought it happened on Mother's Day weekend, then she got a calendar, and that's when she figured out it was April 13th. So I believe that's where that came into. The propensity evidence did not affect this, though, Your Honor. If you remember from what counsel stated at the beginning, Mr. Ballou was convicted of rape and aggravated indecent liberties, but he was found not guilty of the aggravated criminal sodomy. I know specifically there was one part of, it was in one of the interviews, and then it was also testified to by his daughter at trial, that at one point in her bedroom, Daddy put his number 1 and my number 2. That right there is an aggravated criminal sodomy. Now, if that had given the child's definition of number 1 and number 2 prior. So obviously, if that 6455 evidence had played that much of a role in the jury's mind in expanding these dates, then why would he have not been found guilty of the aggravated criminal sodomy as well? The defendant's defense was that he never touched his daughter. It was not date specific. In fact, at one point he was getting ready to call a witness to testify he was with that individual, or we believe he was getting ready to testify that he was with that individual on the 13th, and there was an objection at a bench conference that's in the record. Counsel clearly stated this was not an alibi defense. We don't have our defense is he never touched his daughter.
But was it proper for the prosecutor to say that during closing argument? I understand the sufficiency of the evidence, but I thought you were arguing that there was no error at all, or there was no. Go to that. How is defending against a moving target okay for the prosecution to allow during their closing arguments when the evidence all focuses on something else.
Your Honor, I think when you look at the entire statement that was around there, the prosecutor said this act occurred on or about, very important words, on or about the 13th day of April 14th. And he talked about the confusion between what Virginia said might have been Easter, might have been Mother's Day, but narrowed it down to April 13th.
You're saying it wasn't a moving target. The target was the act, and so the act was the same act that was being targeted all along. The discussion of on or about was just to provide that wiggle room as to which day the evidence showed it happened.
I believe so, Your Honor, because of things that had come up in trial. I don't think that there was any. He was being prosecuted on the acts that Virginia Norris walked in on him assaulting his daughter. That's what he was being prosecuted on. Those never changed. There was of course, Virginia Norris who saw it happen, the victim who testified about it happening in person that day. There's a part in the transcript where she uses the chair that she's sitting in to turn around and demonstrate how she was in the chair when Virginia walked in with her dad behind her. That's what was being prosecuted, and that never changed.
And there was evidence of that being, April 13th being the date.
There was, Your Honor, through Virginia Norris, how I explained that she initially, when she talked to law enforcement, thought it might have been this day, then it might have been this, but they got out a calendar, looked at the days, and that's the day that she said that it happened.
In other words, it's, again, just to clarify, it sounds like you're saying the prosecutor's argument to the jury was essentially, look, you don't have to believe it happened on April 13th exactly beyond a reasonable doubt. You just have to believe that it happened, and it happened within this date range.
I think the prosecutor's argument was that it happened on April 13th, but there might have been a little time in there with the on or about, how that definition is. I don't think he was arguing 4 months before or 6 months before, like the Muir case that defense has cited. Did that answer your question?
Yeah.
Okay. If there are no further questions, I have exhausted my time. The state would just request that the court affirm the Court of Appeals decision, but do find that instead of just assuming for purposes of argument that there was error, that there was not prosecutorial error. Thank you.
May it please the court.
Counsel, just real quick so I can follow up.
Sure.
The date is not an element of this crime, right?
It is not an element of the crime.
Do you disagree with the characterization of the state that this actually wasn't a moving target? They were talking about the act, the she walked in on act, and it was just giving a range of dates on which that act might occur.
I do disagree with that, Your Honor, because the state in questioning Ms. Norris went through how they came up with the specific day of April 13th. And that is the allegation that runs throughout this case, that this occurred on that specific date until closing arguments. And in closing arguments, I don't think the state was arguing that you have to find this happens on April 13th. They clearly are telling the jury that they can find it happened in that date range.
But I don't read it that way. I don't read it that way. He says the act occurred on or about, very important words, on or about the 13th day of April 2014. There's been some confusion about the exact time that this happened, exact date that this happened. There's been some argument that Virginia said, well, at first she said, I thought it would have been Easter, a week before that, or a week after that, maybe Mother's Day, but she narrowed it down to what she thinks was April 13th. Okay, so that's the evidence we have regarding that. I can't read that paragraph without conveying to the jury that we're talking about this act where she walked in, and that there was some equivocation from the eyewitness on the date, and hey, jury, that doesn't matter. How does that convey anything different?
I think if you look at the testimony of Ms. Norris, there's no equivocation, because she said that she went back, looked at her calendar, she knew she quit the day after this occurred. She figured out what her last day of work was and figured out this was April 13, 2014. She was specific on that day. And the state is expanding that when they go on later on to say, so it's not required that you find this happened exactly on April 13th. And that's from...
But that's a true statement of the law, isn't it?
It is a true statement of law, generally speaking, but not when you propose and prosecute based on a specific date and the defendant relies upon it. If they're going to say this happened on X date, they should have to prove that. And my client should know that this is what I have to defend against. And that is what we see as the problem in this case, is that he did not get that notice.
Well, that's a due process. I think that was asked before. That's a due process argument you're making rather than a prosecutorial error, as the prosecutor states what is the law, which is it didn't have to happen on that date, but that happens to work a due process. Then haven't you raised it incorrectly?
I don't think I have, because I don't think the state can get up there and argue something that violates due process. That to me would seem to be a misstatement of the law. And in this case, again, when they are date specific, my client can and should be able to rely on that.
Was there any date specific defense raised? An alibi type defense, or an April 13th would have been impossible for some reason defense?
If you look at the testimony of both my client and his son, they discussed what they did on April 13th. And the argument that they were trying to make was that the window of opportunity was very narrow. They weren't raising an alibi defense, but it was specific to April 13th.
Made it unlikely.
It made it unlikely, that is correct, Your Honor. And they did not go into, on April 10th, this is what I did, or April 1st, this is what I did. They talked about April 13th.
And you're saying it doesn't matter whether we put this in the cubbyhole of introduced legal error or introduced factual error. It just doesn't matter if a prosecutor says something in a closing argument that works a due process violation to the defense. That is outside the wide latitude. That's what you're saying.
I would agree with that, Your Honor.
Okay, I mean, we're just trying, I think a lot of our discussion here today has been trying to classify the type of prosecutorial error you're alleging, and I'm suggesting maybe that doesn't matter. It's generally error if it's introducing a due process, if it works a due process violation because of surprise. That you're kind of arguing surprise, really. What? We're talking about dates other than April 15th.
Sure. I mean, it's a notice issue, ability to present a defense issue, and we think when a prosecutor violates those principles, it's error.
You're arguing factors that courts typically look at when we talk about factual variance, and the cases you cite are based upon law about factual variance, but that has not been imported into Kansas case law, has it?
Testing my recall. As far as factual variance, I don't know that it's been incorporated in Kansas case law. I don't think that here our problem is my client was basically blindsided at closing arguments because the state said this could have occurred at this time frame where he had built his defense on a specific date. So I don't know that that's a factual variance. What I understand, a factual variance could be completely off, but essentially the facts you allege are not what is brought out. And in this case, the facts they alleged were brought out at trial. They argued at trial through the testimony of Virginia Norris, this happened on April 13th. It was only in closing when they brought in that. If I could just make one quick point, this goes to Justice Biles' earlier questions, and I would point the court to its record 27, starting on page 303, which is the start of Ms. Stockard's testimony. She identifies herself as a child protection specialist. She talks about her employment, her education, which includes both the bachelor's and master's. She also talks about how she's had special education continuing education on topics such as interviewing children. She goes on to talk about that she's attended children, this is page 306, I've attended children training regarding interviewing children specifically. What were those trainings? I've attended Finding Words training in 2006, and I attended the advanced course of that in 2007, which was called Beyond Finding Words. There's some additional things about her expertise and training. And I think she doesn't come out and say, I'm an expert, but that is what is being painted for the jury to give credence to that interview, to show that she knows what she's doing and she's doing it right to get a reliable, trustworthy interview.
And that portion of the record is the direct examination?
That is the direct examination. As I said, it starts on page 303 of record, volume 27. With that, I would ask that this court reverse for the reasons that we've stated in our brief. Thank you.
Thank you, counsel. Court will take this matter under advisement.